You're driving down a Massachusetts road. An officer stops you. He asks you, what have you had to drink tonight? And you found yourself suspected of a DUI, of an OUI, DWI, of drunk driving in Massachusetts. What do?
In your mind, you think that that police officer is in control, but you have a lot more control than you think. And the choices you make in the moments that follow that question or that car stop can make the difference between getting away with a ticket or finding yourself arrested for and convicted for OUI. So really, it can happen to anybody. OUI stops happen all the time, depending on maybe the time of night, the road that you're on, where you're coming from. Is it the time when bars and restaurants are closing? The police are out there and they're looking for people to pull over to see if they can make an arrest. Or maybe they have a checkpoint set up where everybody's getting stopped and asked, have you had anything to drink tonight? Under that situation, what you need to do is make sure that you give the police as little information as possible within the confines of the law. So there are a couple of things you're required to do when you're pulled over by a police officer, Ryan. What are those?
So the number one thing is you are required to comply. So when you see those blue lights go on, you are required to pull over safely, swiftly, not too swift, roll down your window and provide your license and registration, your identification and the registration of your car. That's about it.
Right. So once you provided those two things, you've complied with your obligations as a motorist on Massachusetts roadways. And anything more that the police officer wants from you has to be supported by one of two things: reasonable suspicion of criminal activity or objective safety concerns. So unless you have a bazooka in the center console of your car, generally speaking, it's going to be whether or not there's reasonable suspicion of a crime. What the police officer is going to do is he's going to try to develop that by baiting you into answering questions and doing things that are going to show whether or not you're impaired by alcohol in the eyes of a police officer. Really, he's building his case against you at that point. As soon as he smells alcohol or as soon as he observes a motor vehicle infraction that's associated with OUI, like drifting lanes or leaving your blinker on or something similar to that. So all you need to do is give your license and registration, and when the police officer asks you how much you've had to drink tonight, you can simply state, I respectfully decline to answer that question.
Your refusal to provide evidence, your refusal to answer questions, your refusal to perform field sobriety tests, your refusal to take any breathalyzer, none of that can be used against you at trial. So this is important to note, that the thought commonly is, well, if I were not guilty, I would provide this information. So what do I have to hide? The best position that you can take is not providing any evidence so that that can't be used against you at trial. So this is important to note, because when it comes to trial, the evidence is not going to be, I pulled over Ryan, he smelled like alcohol, and he refused to perform anything in order to show his innocence. It's going to be, Ryan had a headlight out, I stopped him, he was polite, he was cooperative, and so I arrested him. That's what the evidence is going to look like, and that's why you have a fantastic chance of winning.
Right, and so what occurred during that time period, I respectfully refuse to answer your questions. I'm not going to perform any field sobriety tests. I'm not going to take the breathalyzer. All those facts are real, but none of it is going to come into your trial. So really, your trial is just as abbreviated as that. Under Massachusetts law, and in most respects under federal law, a motor vehicle infraction stop has to be limited and narrow in nature to resolve as quickly as possible without delving into matters that are beyond the reason for the stop. So once you're stopped, you give your license, you give your registration. The officer has to either give you a ticket or a warning or send you on your way, or he's got to have reasonable grounds to conduct an investigation against you. So what happens then when the police officer asks you, would you mind getting out of the car? What are you supposed to do at that point, Ryan?
So what you're supposed to be doing at that point is asking, am I being ordered to get out of the car? Because a police officer asking you to do something is not necessarily an order. If it's not an order, you do not have to comply with that. If the officer says, no, you're not being ordered out of the car, you can say, am I free to go? If the officer on the other hand says, yes, I'm ordering you out of the car, listen to that. This is not a situation to throw a tantrum or to be difficult. Right. Respond and do everything that the officer is asking you to do, except answering those questions,
right, in
order to make sure that we get those first things that we talked about, that you are polite and you are cooperative, because that's going to go a long way to helping you throughout this.
OUI cases, or DWI cases as they're sometimes called, are not won on the street. They're won in the courtroom, and they're won by depriving the government of the evidence that they're inviting you to provide against yourself. Don't fall for it. Don't fall for the bait. Don't answer the questions. You're never going to convince the police officer that you're fine. The police officer has zero incentive to release you if you smell like alcohol or if you've committed one of those infractions. He's going to arrest you, and then whatever happens with your case happens, but no police officer got in trouble for conducting too many OUI arrests, okay? So really all the cards are stacked in favor of the police officer deciding to arrest you. The least you can do for yourself is not give him the evidence that he needs to convict you. So now let's talk about the point where you have in fact been ordered out of the car. You get out of the car. When the officer orders you to get out of the car, he's going to be watching the way that you get out of the car and using that as some evidence against you. So if you seem unsteady in your feet, if you're swaying, if you leave the car and drive, those are all things that are going to be used against you. So be mindful in that moment where you've been asked to exit, or been ordered, I should say, to exit. So now you're out of the car. What's the police officer going to do, Ryan?
He's going to ask you to perform field sobriety tests. There are 3 tests: the horizontal gaze nystagmus, the 9-step walk and turn, and the 1-leg stand. And what you should be doing, similar to the advice that we've been giving you throughout this entire video, is saying, officer, trooper, I respectfully decline to do that test. I'm refusing to do that test.
Right. Be unequivocal about it. Be clear, because if you're hemming and hawing, that hemming and hawing could be used against you, because they're going to say that, well, he wasn't refusing, he was simply expressing his own belief in his own impairment. So don't fall into that trap. Be very unequivocal. I refuse to take these tests. I decline to take these tests. So the horizontal gaze nystagmus test, you're going to be looking at a finger moving in front of you. The 1-legged stand, you're going to be standing on 1 foot. And the 9-step walk and turn, you're going to be walking in a special way that the officer describes or orders you to do. Don't do any of it. So then at that point, the officer has asked you to take these tests. You refuse to do it. He then offers you a preliminary breath test, or a roadside PBT. What do you do to that?
And so the answer to that, Murat, is you don't take the test. Even though if you pass the test, it might result in you being released, there are other consequences, sometimes hidden consequences, that can come with taking a test that's later going to be used against you. One of the most important circumstances to remember is in whether or not your license loss is going to continue to be justified in the future. So the safest advice for your long-term consequences is you refuse to take the test. Now, it's important to know, refusing to answer questions, refusing to perform field sobriety tests, refusing to perform any sort of breathalyzer. Some people may disagree with us, and they may say, look, I'm going to try to talk my way out of this. I'm going to show the officer that I'm a gymnast, that I'm able to have this balance. That's your right to do so. We are not giving you the advice as to what can be used as to prevent you from being arrested. What we're doing is giving you the best advice we can in order to make sure that you resolve your criminal case with the least amount or no criminal consequences. And that includes license loss consequences after the case is over. And so our advice is you don't provide this information because none of it can be used against you in court.
Right. I mean, so again, reasonable minds can differ. Some lawyers might say, go ahead and do the field sobriety test. I think it's terrible advice. Our 40 years of experience combined will tell you that it's terrible advice to go ahead and take any field sobriety test at all. But if you feel like you're going to somehow convince the officer that you're sober enough to drive, maybe you'll be the record setter for the person that actually doesn't get arrested after performing field sobriety tests. But the reality is you're really just providing evidence against yourself that you're going to have to later fight in court. We've talked about what happens when you stop. You provide your license and your registration. You respectfully decline to answer questions. You decline to get out of the car unless you've been ordered to get out of the car. You refuse field sobriety tests. You refuse the portable breathalyzer test. And now the officer either gives you a citation, gives you a warning and sends you on your way, or he places you under arrest. Let's assume that you've been placed under arrest. Ryan, what's the next thing that we need our audience to know?
If you're still watching this video, there are one of 2 scenarios. 1, the officer has arrested you, or 2, you're my mom. Hi, Mom. Assuming that you're watching this because you've been arrested, the next thing that's going to happen is you're going to be taken down to the police department. That's going to be the nearest state police barracks or the local police department, and you're going to be asked a series of questions. You're going to be asked again, or potentially for the first time, to take a breathalyzer. This is the real breathalyzer, one that can be used against you in court. And there are bigger consequences to remember when deciding what you should do.
So at the police station, the rules regarding what you being able to refuse to answer questions are different. So you have to answer basic biographical booking questions. Your name, your height, your date of birth, your parents' names, what you do for work, that kind of basic stuff, your social security number. You have to answer those questions. If you don't, there could be some serious problems for you. Once that process is completed, you're going to be asked to take the breathalyzer test. And the officer is going to try to give you information that scares you into taking the test or maybe lulls you into a false sense of security that it's in your best interest, never fall for it. Never fall for it. Do not take the breathalyzer test. Not only is the breathalyzer test the most competent and convincing evidence to juries, it's the type of evidence that causes most convictions in our experience. The breathalyzer test has a history of being problematic and can sometimes report false results. So even if you're sober, that machine might say that you're not. So again, don't think that it's going to be a way to exonerate you. It's always going to be a way to hurt you. So you refuse the breathalyzer test. Can you do so and suffer no consequences? Unfortunately, no, because there are license loss consequences for refusing to take the breathalyzer test, depending on whether this is your first offense or your third or fourth offense. It can range from 6 months of a license loss or a lifetime license loss. But the benefit is that if you have followed our advice and you provided no evidence to the government that they can use in order to convict you, then really we can get you back on the road and get that license loss erased really rather quickly and with a high likelihood of success. And can you just walk us through that process, Ryan?
Sure. So it's important to remember that when we're giving you the advice, we're talking about in Massachusetts. There are some, even nearby states, that there are different penalties or potentially even a crime itself to refuse the breathalyzer. That is not the case in Massachusetts. Refusing to take the breathalyzer cannot be used against you. But as Murat said, it is going to result in that license suspension. But what's going to happen is, if you followed all of this advice, you're going to court with your best chance of success. So we're going to court and we're arguing there isn't enough evidence in the police report to bring these charges. We're arguing that there wasn't a basis in order to ask you out of the vehicle, and therefore preventing anything after the officer asks you out of the vehicle from being used against you at trial. And most importantly is your trial is going to have the least amount of evidence possible. It's going to be whatever the officer observed driving, your polite and cooperative lack of answering questions, no evidence about the field sobriety test, no evidence about the breathalyzer, no statements that were made at booking about where your last drink was. And that is a recipe for having a not guilty finding, your case being sealed, and then us filing a motion in order to get your license back. Because at that point, the government has to show that you're a danger in order to keep your license suspended.
Right, so even before that 6-month suspension period elapses, if you can get your case to trial and you are exonerated, which is what's likely to occur if you follow our advice, then the law presumes that you should be entitled to your license back, unless the government can prove some sort of exceptional circumstances that dictate otherwise. Remember, if you're pulled over for OUI, less is more. Follow our advice. Don't do anything other than provide your license and registration. And although it might be unpleasant in the moment, you're going to thank us in the long run.
Bye, Mom.